Hi, I'm Mal from the Money Study, bringing you another episode of our Ultimate PSS Education Series, number 54. This one's a little bit different, but some of you may or may not have heard of this thing called the Cornwall case. Anyway, it's basically helping those people who possibly thought they were wronged by going into the PSS or missing out on the PSS, whichever it may have been. So before we kick it off, there's my disclaimer: facts and figures, information only. This is not advice. Yeah, look, Ash and I, we get confronted with this question all the time from various different people who think that they were wronged at the time of actually going. They were sort of conned, dare I say, to join the PSS when they were in the CSS, or they were delayed in getting into it, or they weren't able to get into it at all, and so forth and so on. But there was a case that basically, well, this guy won. His name was John Cornwall, and he was employed with the Department of the Interior and the ACT government back in 62, all the way through to 1994. And in 1965, when he was eligible to join the Commonwealth superannuation, his manager advised him that he was ineligible to join. Now, the information was incorrect, and Mr. Cornwall was successfully argued in the High Court that he should have been allowed to join the superannuation scheme in 1964. Yep, the High Court found against the Commonwealth in that case, and in April of 2007. Now, importantly, the High Court found that Mr. Cornwall's cause of action against the Commonwealth did not accrue, this is the important part, until he retired in 1994. So even though it happened back in 1965, it didn't actually become a problem as such until he's retiring in 1994, when he was actually accessing, because that was when he was able to get it, his superannuation benefits. Consequently, the legal action he instituted in 1999 was found to be within the 6-year period of limitation. So there's a limitation of when you can go back in time to sort of have a go at people. But in this particular case, it's actually 6 years from the time of when he's been able to access it. So this is the thing where people think, oh, I probably left it too late. Well, there certainly is time. And of course, this was a guy trying to get into the CSS. But the same sort of things still apply in regard to people who, believe things were wrong in the PSS. And so based on the supporting documentation that Mr. Cornwall had, then effectively he got a compensation payout. So in fact, he won. Now, it sounds simple. It's not that simple as far as saying, oh yeah, but I was told years ago that I should have been, I should have gone to the PSS. Now, I will be doing an episode on PSS compared to CSS, and I think you'd be a bit surprised. I don't think a lot of you really should be too upset by moving into the PSS, and in many cases I actually prefer the PSS. Anyway, I'll do an episode on that. But just in case that you missed out on getting into the PSS when you should have done, or you didn't get in at all, there are some things to think about if you're going down the path of a claim that's similar to the Cornwall case. So these are the sort of criteria that the Department of Finances have basically said, we're not even going to look at it unless you can sort of satisfy these criteria. And so the number one criteria, obviously, that you were eligible, that you really were eligible to apply to join the super scheme in accordance with the rules applicable at the time of the alleged negligent misstatement. So basically, were you really entitled to join that scheme at the time when you were, when you could have done, so to speak? Then that you received incorrect advice, so this is basically negligence, from a person in authority, so it's your boss, your boss's boss, or or something from your department indicating that you could not join the relevant superannuation scheme. So it could be something from your HR, payroll, that would be a person in authority, or your boss, or someone who's looking after you, basically saying, no, you can't do it. And of course that you then relied on that advice, so, and you would have joined, had you not relied on that advice. And so, so you missed out because of this wrong advice. And effectively, and this is of course where this Cornwall thing came into it, submitting a claim within 6 years of the date that you retired, or some other trigger which would have allowed you to access it. So I suppose that could include if you got made redundant or something like that earlier. But generally speaking, we're looking at when you could have accessed it, 55, retirement and so forth. And of course, you need to demonstrate that you did indeed suffer a quantifiable financial loss. Well, if you couldn't get into the PSS, I think that would be pretty easy to demonstrate that you could have been better off had you been in the PSS in the first place there. So those things, they're pretty mandatory. You've got to be able to satisfy all those before you'll even be considered. And the difficult part here, of course, is that it's if you can't just say, look, my boss told me at the time. That's just a he said, she says type of scenario. Really, you would need some form of documentation. And this is the problem, who's got the paperwork? And yes, I have had clients who do have the paperwork and have had successful claims even as early as last year. I had or as late as last year that one of my clients made a successful claim because he went through all his paperwork, he kept everything, and sure enough came across letters and emails and so forth, basically instructing him that he couldn't, and all the instructions were effectively wrong. Now, you might want to get into the Public Sector Scheme Superannuation Act. You can actually download the actual legislation for this public sector. There's ones for the CSS and super and so forth there. That's why I've got number 3 there. But basically, I've just taken the bit here from the public sector section. And so there's a lot of information that you can get from that. It's pretty dry reading, I can tell you, from reading the Superannuation Act of 1990. Anyway, and of course, a lot of the issues did come around temporary employees. I think that's one of the ones where they really were led astray. You're temporary, you can't join the PSS. Well, a temporary employee could elect to join the PSS if they were employed under a contract for a period of 3 months or more. So that's a sort of a line in the sand there. Or had accumulated 3 months employment over the preceding 2 years prior to their current contract, or had a transfer value from another employer that they intended to pay into the PSS. Now that's a pretty broad sort of, meaning they've got money from another super fund, so that they were intending to pay. Interesting one, and completed a medical examination. So a few little fine points there for the temporary ones. Now, if all of this you think, yep, I satisfy the criteria, I've got some information I think would satisfy everybody. Well, you can make a claim by registering with the Department of Finance by completing a questionnaire, and there's an application form just for this particular scenario. And if you go to that website down the bottom there, you might have to freeze the video and write it out, or literally, if you just go to the finance.gov.au and look under the claims and management, you'll come, or just even put in search Cornwall superannuation case, you'll come up with all the information you need there to be able to find the paperwork. If you can't find it and you're looking for it, then just give us a buzz and we'll dig it out for you. If you just want to have a chat about all of this and just trying to get a few of the finer points, then we're happy to help. But I will, I'm trying to save you money here. Don't just book an appointment if you thought, my boss years ago told me to, get out of the CSS and go to the PSS. That's not a case that it will stand up. You've got to have some form of paperwork or a witness or something to back it up. Something to back it up. You can't just say, look, my boss told me. That will not work. Okay. Anyway, there has been a couple of class actions and so forth. I'd be a bit careful of joining a class action again, because it really does come down to you pay money to the solicitors in these situations and so forth, and the chances, if you've got no documentation to be part of it, yeah. Anyway, do your research, do your homework. There's going to be some people, who have missed out and shouldn't have missed out, and there'll be other people that missed out because they just weren't paying enough attention at the time. Okay, good luck with that one. We'll talk again on another session.